A group of civil society groups are now asking government to drop the new Public Procurement Bill, despite the fact it's already been passed by the National Assembly. The bill is supposed to manage how government procures goods. You know how many tenders and problems we see in the procurement space. Already, the Chief Justice, Raymond Zondo, has said that 6 of the 10 recommendations he made to stop corruption in procurement have been ignored in this new bill. Ryan Brunette is a research associate at the Public Affairs Research Institute. Ryan, good afternoon to you and thanks for your time. What do you believe is wrong with the new procurement bill?
Hi, Stephen. Thanks for having me. I wouldn't say we're planning on redrafting the entire bill, creating a new bill and so on, right? We do need new legislation in this area. In our view, the bill is salvageable. It just needs fairly sustained and serious attention from this point before it passes into legislation. Before the president signs it. It's a complicated bill. Just to start this off, we're talking about arguably one of the most consequential pieces of legislation that's being advanced by President Ramaphosa's administration. This bill will govern how government spends around R1 trillion annually, which is about a fifth of gross domestic product of South Africa's economy. We're really just worried that, the statute isn't receiving the kind of sustained, detailed attention that it deserves, and that the country is in important ways kind of walking into potential catastrophe here. The bill's complex, and I won't go into all the kind of issues that we may have with it. But at this point, the major kind of concerns that we have first lie in the area of kind of integrity and transparency and so on. We all know that there's kind of runaway corruption in the public procurement system. Bolstering the integrity of the system is extremely important. We're a little bit dismayed to see that in the National Assembly, there's actually been some rolling back of integrity provisions. Earlier versions of the bill that was introduced into Parliament, automatically excluded, say, party political leaders from participating in public procurement. It automatically excluded relations of employees of state from participating in procurement within the kind of procuring institutions that they're working in. Those have been now removed. There's various kind of fairly detailed issues in transparency. We're worried about, the confidentiality clause in the bill is a little bit too broadly conceived. We wanted to align more closely with the Promotion of Access to Information Act. There's other features of the transparency provisions in the bill that we're quite in favor of that are forward-leaning and progressive. These include kind of beneficial ownership transparency and so on.
So Ryan, I'm sorry, let me interrupt you at that point. This issue around transparency. So as a journalist, I always want to know who's got the contract, right? And who's really got the contract. Under this bill, would it make it slightly difficult for me to know who really owns a company who got the contract, or who really actually is the ultimate person who's benefiting from it? I mean, would it be difficult to find that out?
I guess that's kind of a little bit up in the air at the moment. There's some very kind of progressive provisions which basically say that the state must proactively disclose on the central portal the names of whoever gets contracts and the beneficial ownership of the companies that get contracts. So that's I would say a radical advance in transparency if it's effectively implemented. The trouble comes in with there are kind of grounds for confidentiality in the bill, and one of those grounds in particular is the protection of personal information. And we're worried that that ground and the way it's kind of drafted may interfere with the release of those names. So in some ways, what we're asking for in this area is a fairly kind of quick, easy rewrite that may have huge advantages down the line.
Do you think there's any political appetite? I mean, I suppose we need to go back a little bit. Why would some non-progressive measures be included? Or why, to use what Chief Justice Zondo said, some measures that he suggested would improve transparency and reduce corruption in procurement, why were they taken out? I'm trying to get to motive, and I know motive can be quite difficult, but let's make it to the heart of the issue.
I mean, I'm not going to kind of speculate about any kind of malign intentions. I don't think that they're there in this particular area. I think this is just like I've been with this bill for many years, and I think this is just like a misdraft, actually. I think there is some appetite within the National Treasury to at least include beneficial ownership transparency and so on in law. And that, it's just this kind of like fairly tricky legislative issue that needs to be resolved. And I think it's entirely resolvable. So no, I mean, I wouldn't say that there's like a malign interest in the background that's kind of forcing this through. In this particular area, I think we just need to kind of like get onto the same page regarding how exactly to draft that provision.
One of the, Ryan, you made the point that this is complex. One of the very complex issues is around preferential procurement. So it's about trying to make sure that black-owned companies benefit, that they get contracts. It's about trying to make sure that locally based companies benefit. If you're doing a big government project in a particular area, then a company based there would benefit. What does the bill say about preferential procurement? And I know there's been legal action and all sorts of discussion about this.
Yes, I mean, maybe it's useful to start with, like the way we approach this is maybe a little bit unconventional in the South African, public debate. The public debate is fairly polarized. It's actually very simplistic. It tends to kind of hinge on whether it's kind of like, start to completely phase out preferential procurement or to like radically expand it. We're not really interested in engaging in these sorts of polemics. In our view, the kind of like constitutional, political, and economic reality is that South Africa must kind of thread the needle on this one. We need to construct a preferential procurement framework that simultaneously sustains and expands the economy and also deracializes it. This has got to happen, right? We're concerned that what's happened with the bill is that over the last few months. Preferential procurement was thoroughly redrafted. There's a whole new, fairly detailed Chapter 4. In fairly complicated ways, it's kind of like dissonant. It doesn't fit so coherently within the broader Act as it is. And what it does is, create kind of like vast space for kind of reallocation of contracts across the economy, which could have like pretty severe consequences for state capacity and economic productivity and so on. What that includes is, set-asides, for example. So there's a whole range of categories through which, government can decide that only certain categories of business can participate in a particular contract, right? There's that's rolled out in the current Chapter 4 in quite kind of vague, unclear, and open-ended ways, right? We're not against set-asides. They can be a useful mechanism for various reasons, but it does need to have appropriate safeguards, and it does need to be drafted in a way that's kind of clear, that kind of communicates clearly what government is trying to do and so on, at the state, etc.
Ryan Brunette, thank you. Research Associate at the Public Affairs Research Institute. Do appreciate the time.